hairs that may or may not have been on the Bundy glove?
No.
Your same answer as before?
Yes.
Now, did I understand your testimony yesterday to indicate that you had someone bring you the glove that was allegedly found at Rockingham over to you at Bundy? Did you so testify yesterday?
The glove was already at Bundy because that's where the criminalist had just come from. So he came to Bundy, and at that time I requested to take a look at the glove.
Had you asked to have that glove brought over?
No, it was brought over with the criminalist after he concluded his investigation at Rockingham.
And so we're clear about the criminalist. What criminalist are we talking about?
Mr. Fung.
And how did he bring it over, if you know?
He drove over in his truck.
And, well, other than by the truck, where was the glove when you first saw it?
In a brown paper bag.
And was anything else in that bag?
I don't recall seeing anything else in the bag.
And you told us yesterday how you examined this particular glove. Do you recall that?
No, I believe I just said that I looked at it briefly, and then we went over to the truck, and I examined it further at the rear of his truck.
All right, let's go back. Where were you when you first saw the glove that allegedly had come from Rockingham? Where were you in relation to the Bundy location?
I was at the rear of the criminalist van.
And what time was this?
Yeah, I could only estimate.
Your best estimate, what time was it?
I mean, perhaps 10:30, 10:45, 10:20, I don't know.
All right, and you saw it, Fung had it in his hands at that point, is that right?
No.
Where was it?
It was in a brown paper bag.
All right, well,
he brought it over to me at the scene and said he had it and suggested that we go to the truck to look at it, which we did.
The question was, did Fung have the paper bag in his hand at that time?
That's my recollection.
All right, that's what I'm asking you. And then at that point, did you visually look inside the bag?
Again, I don't believe I did at that point. We walked to the truck, and that's when I looked inside the bag.
All right. And when you walked inside the truck, who was present inside that truck when you looked inside this bag?
Okay, we were at the rear of the truck. Fung opened the bag and showed me the glove.
Can you answer my question? Who was present inside the truck at the time you looked inside the bag?
Fung and myself.
Just the two of you?
That's my recollection.
All right. And, of course, you've written all this down in your report. You wrote this down in your report, did you not?
I wrote what down?
The fact that you saw the glove, the back of the criminalist truck, along with you and Fung. You wrote that in some report,
No.
didn't you?
No.
I can't hear you.
No.
That's not written anywhere in any of your reports, is it?
I would have had no reason to write that down.
The answer is that written anywhere in any of your reports, Detective?
My answer is, Mr. Cochran, no.
All right. And you have never before yesterday ever testified about that. Isn't that right?
If I haven't been asked about it, I certainly wouldn't testify about it.
Let me ask you this. Did you ever before yesterday afternoon ever testify about looking at the glove allegedly taken from Rockingham at the Bundy scene along with Mr. Fung? You ever testified to that before?
I've never been asked that.
All right. There's never been any of your reports. Is that correct?
There would have been no reason to put it in any report.
The answer is no?
That's correct.
Now, so when you then looked inside the bag, inside the truck where you and Fung were, did you have occasion to touch the glove at that point?
I did not.
Did you take the glove out?
No.
And did you ever do anything with regard to the other glove, the so-called Bundy glove? Did you bring it over and look at it?
I didn't touch it.
You never touched it at all that day?
The Bundy glove?
The Bundy glove.
I don't recall touching it at all.
By the way, with regard to this evidence that was moved that you were talking about yesterday, and you told us how these bodies were in close proximity, did you see the evidence moved as the bodies were moved? And by the evidence, I mean the cap, the glove, and that envelope. Did you see that evidence moved?
No.
I'm asking this cross-examination. Did you see evidence moved in this case?
I didn't physically see it, no.
But when I was originally with you on cross-examination, I showed you those photographs. You acknowledged the evidence had been moved. Isn't that correct?
It was obvious to me it had.
And that's the first time ever, in this case, you ever became aware that the evidence had been moved. Is that right?
When you showed me those?
Yes.
No.
You knew it before that?
I observed the photos prior to that, yes.
All right. And did you go and write a report about that, detailing how and when that evidence had been moved?
I wouldn't have known how and when.
You may answer.
No.
You've never written such a report, have you?
No.
And with regard to things like the ice cream, you never bothered to test the melting rate of ice cream until I started asking you questions. Isn't that correct about that?
Until you made it an issue, that's correct. It was of no evidentiary value to me at all.
Well, as the investigator, again, if you made one of your mistakes that you make on occasion, perhaps we call it to your attention. And now you're now testing ice cream. Is that correct?
It's argumentative. It's also badgering the witness at this point.
With regard, let me rephrase it, Your Honor.
Please.
With regard to the ice cream, the first time that you ever did any tests regarding the ice cream was after we started talking about it here in court. Is that correct, sir?
After you made it an issue, that's correct.
And so the answer is yes?
Yes?
All right. And with regard to, let's talk about the ice cream. Yesterday, in response to one of Ms. Clark's questions, you indicated that about seeing some substance in the ice cream. Do you recall that?
Some substance
Yes. You remember you said something about seeing something inside the ice cream?
that
or
appeared
the
to
ice
be...
Hold on. Detective, let him finish asking the question before you start answering, please.
Okay.
Do you remember so testifying about seeing something in the ice cream after it had melted, sir?
I remember saying I believe there was something lumpy.
And do you recall being asked questions about that earlier, about the ice cream, in my examination, when I asked you some questions about that?
Yes.
Do you recall being asked this series of questions and giving these answers? Counsel, it's at page 15369 and 15370. I've got it printed out of the trial transcript. Tell us what you saw when you went in through that door, sir, went upstairs. Answer, I entered up the stairs, and to the left was a banister, which I observed a Ben & Jerry's ice cream cup. It was pointed out to me by Detective Phillips. To me, it appeared to be melted or melting. I asked Detective Phillips if that had been observed earlier. He stated, there's an objection by Ms. Clark. He gave you some information about the observations of the first officer on the scene. Answer, yes. Question, did you observe what kind of ice cream that was? Answer, no. Remember so testifying in Ms. Clark's direct examination that you didn't observe what kind of ice cream that was at that time? Remember so testifying?
Yes.
Now, yesterday, when you were asked, you told us that you thought it might have a lumpy area in the center. Is that correct?
I believe I was asked if it had something like that, yes.
You didn't tell us about that before, did you?
I believe I was asked about that before.
Now, with
Overruled.
now, with regard to your investigation into the ice cream and the type of ice cream, when did you start that investigation?
As to the melting rate, I believe it was last week, perhaps the week before.
The week before, meaning, let's look at the calendar. Which week are we talking about? The week of February the 20th, sir?
I believe it might have, in fact, I believe it might have occurred on the, yes, I believe it was that week, 20, 21, 22.
In that area?
I believe so. I could be mistaken.
And in the course of your investigation, have you talked to a young lady by the name of Berman at all?
Have I?
Yes. Have you or anyone in your direction, sir?
I believe someone may have. I didn't.
I mean, in the course of this investigation, it started sometime the week of the 20th, I'm talking about now.
In regards to the ice cream?
Yes, sir.
I have not since then, no.
You've not since then?
No.
Who else have you talked to in the course of your investigation?
I spoke with the Brown family and the children through the Brown family.
All right, anyone else?
Detective Payne, who I requested to conduct this examination.
And examination, when you say, you mean investigation?
As to the ice cream, the examination of the melting rate of chocolate chip cookie dough.
So you had him go out and buy some chocolate chip cookie dough and then try to see how long it took to melt? Is that what you did?
Essentially, that's what we did, yes.
Were you present when Detective Payne did this?
No.
Were you able to ascertain how many members of the Brown family on that particular night purchased ice cream?
I was told how many purchased ice cream.
You were told that by the Brown family?
That's correct.
Brown family.
I'm sorry.
The Brown family? Over here.
Do we have any Brown family members present in the courtroom?
All right.
Proceed.
All right. In regard to Detective Payne, just a second here. With regard to Detective Payne, has he given you a report of his findings regarding the ice cream?
I have photographs.
And in those photographs, are they taken in a sequential fashion so that you are able to determine how long this particular ice cream would take to melt? Is that right?
Yes, in 5-minute increments.
All right, and you found out that that particular ice cream would melt in a little more than an hour. Isn't that right?
Approximately an hour and 15 minutes under those conditions.
So if that ice cream was solid at 11 o'clock, someone was eating at 11 o'clock, you would expect that it would be melted then by about 12:15 or thereafter. Is that correct? Or in a melting state?
Not if it had been placed in a freezer.
Well, I didn't ask you that. I asked you whether if the ice cream was eaten by somebody at 11 o'clock and it was seen an hour and 15 minutes after that, you would expect it would be melted. Isn't that right? Under your test? I'm asking you.
Sustained.
Basis, Your Honor?
Foundation.
All right.
Speculation.
Okay. Now, with regard then to this ice cream, you're able to find out that this ice cream would melt in about an hour, hour and 15 minutes, testing it in 5-minute intervals. Is that right?
Under the conditions that we had, yes.
Now, if Risky found the ice cream still melting at 12:40 a.m., and you extrapolate backwards, would that mean that the person may have been eating that ice cream as late as 11:15, 11:30?
I couldn't say.
All right. Well, you have this test from Detective Payne, don't you?
Well, I have this test, but this test isn't the definitive answer as to melting ice cream. If you had placed this ice cream in the freezer and refroze the ice cream, it would change everything.
Well, do you think someone placed this ice cream in the freezer when you know, in fact, that the ice cream was found on the banister where it was when you found it, sir?
I don't know when it was last frozen. It may have been placed in the ice cream prior. I don't know.
I see, sir. All right, at any rate, your investigation on the ice cream continues. Is that correct?
That's correct.
And you're doing other investigations also. Isn't that correct? That continues, that you've started after this trial. Isn't that correct?
We get information on a daily basis, and we conduct this investigation on a daily basis. Everything is ongoing.
Do you ever investigate any clues that lead away from Mr. Simpson? Have you done that?
Yes.
All right, what clues have you conducted? We have just a moment, Your Honor. Maybe approach for a second.
Sure.
Detective Lange, why don't we come back to the clues and what you pursued after lunch, if you don't mind. Let me ask you some questions about your theory about this not being a drug-related homicide. You ever heard of something called a Colombian necklace?
I believe so.
And it's true, is it not, that a Colombian necklace is a situation where drug dealers will slice the neck of a victim, including the carotid artery, in order to kill the victims and to instill fear and send a message to others who have not either paid for their drugs or have been informing to the police. Isn't that what a Colombian necklace is?
I've heard that.
And, sir, isn't it true that you, in your experience, know about drug killings where knives have been used? Isn't that correct?
I do have knowledge of knives being used, yes.
And, sir, in this connection, you are aware, are you not, that Faye Resnick became a resident at Nicole Brown Simpson's place at 875 South Bundy on or about June 3rd, 1994. Isn't that correct?
No, I'm not.
All right, your superficial investigation didn't reveal that?
Initially, the investigation revealed she may have been. I've since received information that she was not a resident at that location, and that is ongoing.
You're still looking at that?
Yes, we are.
All right, well, in the course of your investigation, have you learned that she moved in with Miss Simpson on or about June 3rd, 1994, and stayed there until June... May I finish the question?
Finish the question.
And stayed there until June 8th, 1994, at which time she went into drug rehabilitation.
Sustain.
All right. Does your investigation reveal that Faye Resnick went into drug rehabilitation on or about June 8th, 1994, and that she was living at Nicole Brown Simpson's?
Sustain.
I'm asking this investigation, Your Honor.
Counsel, it's a compound question.
All right. Let me restate it then, Your Honor.
All right.
In the course of your investigation, did you learn that...
Wait. That assumes that something is a fact. Did you consider, when he formed his opinion, did you ever consider these three factors?
All right. Thank you, Your Honor.
And it's only on the basis of forming an opinion. Not assuming it to be true.
Thank you. In the course of your forming your opinion...
They will, as soon as I hear what the question is.
In the course of your investigation in this matter, and your determination that this was not a drug killing, did you consider the fact that Faye Resnick went into a drug rehabilitation facility on or about June 8th, 1994?
Overruled.
Consider that fact?
I have been told that she had.
The question is now, not what you've been told, sir. Did you consider that fact when you came to this conclusion you told us about yesterday?
When I came to that conclusion I told you about yesterday, I didn't have that knowledge.
All right. So there are other facts that are coming into your knowledge even as we speak in this case. Is that correct?
Every day.
All right. Now, if, and I want to ask this as it relates to your opinion, if Faye Resnick was freebasing cocaine on a daily basis at the Bundy location, so much so that she had to have a drug intervention by June 8th of 1994, and you learned that to be a fact, would that change your opinion about this possibly being a drug-related killing?
If I had that information, that would probably be a consideration if I had no other direction to go.
All right. And if you found out that as she used this cocaine and was freebasing on a daily basis, she had no job by which to pay for these drugs, would that be a factor that might bear upon the opinion you gave us yesterday? That's going to relate to his opinion.
Ladies and gentlemen, this is what counsel is posing to the detective, or what are known as hypothetical questions. The witness is asked to assume to be true certain facts and then asked to give an opinion based upon those assumed facts. If those assumed facts turn out not to be true, then you can take that into consideration in evaluating the opinion that is given. Mr. Cochran.
Thank you. I don't think we had an answer to the last question. Do you want the question read back for you?
I think I understand it. If I had been pursuing that line, that certainly would be a factor I'd look at, yes.
And you understand that when individuals get drugs, they sometimes will pay for them in cash. Sometimes they get them on consignment. Isn't that correct?
I've heard of that.
And in your experience as an experienced police officer, when people are given drugs, the drug dealers or the people who give those drugs want to be paid. Isn't that correct?
I would assume that.
And sometimes in your experience, you know that when drugs are not paid for that have been gotten and used, there are repercussions. Isn't that correct?
Certainly.
And hence, sometimes, and that's why you've heard this term, Colombian necklace. Isn't that correct?
I've heard that term, not necessarily in connection with every murder I've ever handled.
Well, it can also be for payback for not having paid for drugs. Isn't that correct, though, sir?
I suppose it could be.
And in the course of your investigation, if you were to learn that Faye Resnick was in this drug treatment facility on June 12th, 1994, and that she, in fact, called Ms. Nicole Brown Simpson that evening from the drug treatment facility, would that be a fact that you might find relevant in the course of your investigation and your opinion regarding whether drugs were related in this manner?
Again, if I were pursuing a drug-related homicide, that would probably come into play, yes.
And would it be relevant to you, if you were pursuing a drug-related homicide, that Ms. Nicole Brown Simpson was present at the intervention in which family and friends of Faye Resnick, including Nicole Brown Simpson and her former boyfriend, Christian Reichard, insisted, because of the state of her freebasing cocaine, that she go and get some help that same night and leave Nicole Brown Simpson's residence? Would you consider that as one of the factors if you were pursuing this as a drug-related homicide?
If I were pursuing it as a drug-related homicide, I would probably want all of those factors, yes.
In other words, as an experienced investigator, you'd want to know all of those things, and you'd want to determine what bearing, if any, they had. And that would be more than a superficial investigation. Isn't that correct?
If it led in that direction, certainly.
Very well, Your Honor. Maybe we stop at this point.
All right, ladies and gentlemen, I have a couple of matters I need to take care of out of your presence. I'm going to excuse you for lunch now. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations till the matter has been submitted to you. Do not allow anybody to communicate with you with regard to the case. All right, let's excuse the jury, and let me see Mr. Walsh and one counsel from each side at the sidebar, please. Not present. Mr. Cochran, anything you want to address or bring up before we invite the jurors to rejoin us? And Mr. Robertson, would you ask if Mr. Hodgman will be down here at 3:15 so we can clear up some of those things? Mr. Scheck, any items we can clear up so we can turn you loose for the afternoon? Any items we can take up with you so we can turn you loose for the afternoon? He mentioned he wanted to...
Yes, we submitted a letter to the court with the transcript of yesterday's testimony with the witness and some of the colloquy, and made a proposed curative instruction. And I think our letter speaks for itself, and I would urge the court to give the instruction as written.
Okay. Ms. Clark?
Yes, Your Honor. The people have also submitted the proposed admonition. I think that counsel's letter is an extreme exaggeration of both the importance and the impact of the question and answer that are an issue, and the requested admonition goes far beyond the pale of anything necessary. We all know this testimony is going to occur. This evidence is going to be presented. Counsel's proposed admonition makes it sound like there was a devastating thing that occurred in court yesterday, and that's not the case. That's simply not the case. I think that if anything is at all required here, it's that the answer and the question be stricken, period.
All right. Thank you, counsel.
In reaction to that, I think it's clear from the letter the difference between the curative instruction that we offered and the one the prosecution offered is that we are essentially saying that the questions were improper, but that Detective Lange does not have the scientific training or qualifications to state an opinion about these test results, and you're instructed to disregard his answers. I think that is reasonable and plain, and I think as I lay out in this memo, the prosecution is well aware of the scientific issues with respect to the blood scrapings and the tests. They're subtle, they're complicated, and I think that they plainly gained a tactical advantage here. And in looking back at the record, I think it was much more egregious than any of us thought. First of all, the question, are you aware of the results of those scrapings, the DNA tests, that the DNA tests on the nail scrapings? Yes, I am. And did that testing reveal the blood to be hers? Yes. Now, that question everybody knows is improper because no DNA test can do that definitively. But more importantly, the prosecutor yesterday indicated that she was trying to raise this in the first place, just to show how, as obliquely, just to show how this detective's investigation, or the focus of his investigation, changed. And that really can't be the case, because these tests were performed after the trial started. So to be claiming that she was asking these questions to focus, to explain how the detective's investigation went before the trial started, is illogical and without any factual basis. I think what was clearly going on is Ms. Clark was trying to elicit DNA test results from a witness who was not qualified to do so in order to gain a tactical advantage in terms of when the testimony would come out from the scientific witnesses, where it will come out quite differently in terms of direct and cross of the proper witnesses. So I tried to craft an instruction that was limited, particularly in light of the discovery violation, and it seems to me perfectly plain that Detective Lange, who seems to have far-ranging expertise in lots of areas, but I'm sure one of them is not, that he is qualified to state an opinion about these DNA test results, and it seems fair to tell the jury to disregard it, because I think that's the way we were prejudiced.
All right. Thank you, counsel. If you feel compelled.
Only that the curative instruction requested is inappropriate. The question was neither inappropriate nor improper. The only issue was discovery. I, in good faith, believe that they knew of these results, and that's really the issue I thought the court was addressing. And Detective Lange did not offer a scientific opinion of any kind. He simply indicated it did not change the focus of his investigation. And that had to do with the impact on his state of mind, the issue as to rush to judgment, the issue as to his theory of the case, which is continuing to be a line of cross-examination that is being engaged in by counsel. Obviously, the response to that line of questioning is there's a wealth of physical evidence that indicates that these are not drug-related killings, that this is not the result of some Colombian cartel or some mafia killing. And that's what this line of questioning goes to. It was opened up on cross-examination when counsel began to ask about drug-related killings and other motives. And in response to that, the people were appropriately entitled to say what led you to file and what leads you to conclude to this day that you have made no mistake in requesting the filing in that manner. And I mean, that's the big picture. That's where this all fits in. And there's no effort to mislead or confuse a jury, quite the contrary. The court knows that the people will present witnesses, experts, to testify in much more detail as to the nature of the testing and those results. But at this moment, all we were asking to do was ask Detective Lange to testify to his state of mind and why he bases his opinion, what he bases his opinion on, and why he does not believe it to be drug-related killings. So I mean, it's a totally separate line of inquiry. Mr. Scheck is missing the point. What the court, I thought, wanted to address was what turned out to be a discovery issue, which the people were, I was not aware it was a discovery issue, knowing that the defense expert was standing over their shoulder literally when the testing was done. I think I'm entitled to believe that they would know what those results were, and I'm not so sure that they didn't. Nevertheless, I understand the court's concern. That's why, at best, the court should instruct the jury to disregard the question and answer and advise them that that subject matter will be taken up by the expert witnesses at the appropriate time.
Right,
and I think that more than adequately covers the situation.
All right, thank you, counsel. I think we've exhausted our discussion on this. All right, Mr. Cochran, you had one other matter that you broached before we broke.
Yes, just an area of inquiry, briefly, Your Honor. With regard to the prosecutor elicited some testimony that this detective followed up all of these leads and clues and everything. And I think the question I pondered or proffered was whether or not he'd followed up any clues or leads that had pointed toward Mr. Simpson's innocence, and I wanted some documentation of that. That was the area we were looking at, just briefly.
All right, I had sort of anticipated you were going to launch into a litany of 450 leads that were otherwise.
No, Your Honor, I mentioned to the court yesterday, you should never presuppose anything with regard to me. I think that I'm perfectly capable of telling the court that's all I'm planning to do. And that's what I wanted to ask. I wanted to ask him about it. In fact, we can ask him now.
All right, then I misunderstood
that's
the import of your comment.
Sure.
All right,
Right.
then let's proceed.
May I approach, Your Honor, with the witness a minute?
Sure.
With regard to that? Thanks.
Ms. Clark? Ladies and gentlemen, Detective Tom Lange is still on the witness stand on recross-examination by Mr. Cochran. Good afternoon again, Detective Lange.
Afternoon, Your Honor.
You're reminded you're still under oath. Mr.
Yes.
Cochran, you may
Continue.
continue with
Thank
your
you, Your Honor. Thank you.
cross-examination.
Good afternoon, ladies and gentlemen. Good afternoon, Detective Lange.
Afternoon.
With regard to the clues that you spoke about, I guess, yesterday and this morning that you've investigated, are there some clues that other members of your team have pursued that would be of an exculpatory nature as they relate to Mr. Simpson that would point toward his innocence?
Possibly of an exculpatory nature, yes.
And there are some clues like that you have not personally investigated, is that correct?
I believe so.
And would Detective Payne be one of those who've looked at those clues?
Detective Payne supervises the assignment of those clues to a great extent and has those clues in his computer.
And if I would ask you to search through your computer to give us a computer run of the number of those clues and what the status of those clues are, could you do that over a period of time?
Yes,
And are you willing to do that?
certainly.
And do you have a ballpark estimate of how many such clues there are now pending?
I would have no idea except to state that they've all been turned over to you. I haven't reviewed personally each and every one, so I don't have any idea.
And in that connection, as I understand your testimony, those clues regarding innocence or whatever come in pretty much on a daily basis, is that correct? Clues in this case?
No, not necessarily.
All right, but let me rephrase it. You still get clues in this case on a daily basis, isn't that correct?
Practically.
And so the investigation in this case will and must continue because of that, is that correct?
That's correct.
All right, and so you'll try to get that for us, and if we can finish you today, you can perhaps bring that back at some later time, is that correct?
Well, again, I've turned over all clues. It might be very subjective as to what is exculpatory and what is not. I might suggest that you have your people look at those also.
We will do that.
Because you may interpret something as exculpatory and I may not.
Okay,
So I really don't know.
one person's exculpatory may be another person's inculpatory. Is that what you're saying?
Certainly.
All right, we'll make that judgment, but you'll give us what you have. Is that correct?
We'll make that attempt, but again, I don't know exactly what you're asking for.
All right. Well, I appreciate you doing that. Now, with regard to the subject of ice cream, you know, you said yesterday that photographs tend to memorialize what's at the scene, and that seemed to be a fair statement. And in this instance, you did not take any photographs of many of the things that were in the interior of that residence. Isn't that correct?
That's
Have them
correct.
taken? And we've established previously that you didn't take any photograph of the ice cream, right?
That's correct.
Now, with regard to that, have you personally or anyone in your direction talked to a young lady, I believe is 8 years old, thereabouts, whose name is Rachel Berman?
I don't know if Rachel was spoken to or her mother. I believe her mother was.
All right. And with regard to the kind of ice cream that you had the detective do a test on, I think you told us that was some kind of, what ice cream was that?
Chocolate chip cookie dough.
All right. And were you also, did you run any test on an ice cream flavor named Rainforest Crunch?
No.
Did you have information that Miss Nicole Brown Simpson that night had, did you have information that night? May I finish the question, Your Honor?
Yes.
In the course of your investigation, did you have information that on the night of June 12th, 1994, Mr. Cole Brown Simpson purchased an ice cream called Rainforest Crunch?
No, my information was the chocolate chip cookie dough, and I believe there was a chocolate chip.
And so your answer is no, you didn't have it. It was Rainforest Crunch?
That's correct.
So have you, in your voluminous materials, do you have any statement, or have you read a statement from Rachel Berman, who apparently was with them that evening? Have you read that statement?
And-
Oh, well,
Read a statement from Rachel Berman?
As to what kind of ice cream they purchased when they went to Ben & Jerry's?
No, I received that information through the Brown family as to what
All right.
each one of the three children purchased.
All right. Would you think it would be helpful, from the course of you strike that, in your investigation, you learned, did you not, that the Brown family themselves were not with Ms. Nicole Brown Simpson and the children and Rachel Berman when the ice cream was purchased? Did you not find that out?
They just left them when they walked across the street. That's
So
correct.
they weren't with them. Now, would it be helpful to you to talk to a child, not involved in this case, who was present when the ice cream was purchased? Would that be helpful?
That was done through the Brown family.
I'm asking you, would that be helpful for you to do that?
Yes.
Now, the Brown families, they aren't members of the Los Angeles Police Department, are they?
I was advised by the Brown family that I could not talk to the children, that they were under the care of a child psychologist, and so I respected that.
I understand that. You told us that yesterday. I'm asking you now about Rachel Berman, not the Simpson children. I'm asking you, have you or anyone in your direction talked to that child individually?
As to the ice cream,
Yes.
no. Again, that was done through the Brown family.
Well, as the investigator, would it be helpful to you to talk to a child who was present, sir, and find out about the ice cream?
Yes.
Did you find out at any point that, let me ask you this, did you find out at any point in the course of your investigation that the flavors purchased were Rainforest Crunch? Did you ever find that out?
I don't recall Rainforest Crunch.
All right. Did you find out that one of the flavors purchased was chocolate fudge?
Yes.
Did you find out one of the flavors purchased was cookie donut?
I believe it was cookie dough. My information was 1 chocolate fudge and 2 cookie doughs.
All right, but you've not talked to Rachel Berman yet, right?
I have not talked to Rachel Berman.
Now, in this, bless you, you described for us that before lunch about these drug killings, and I asked you some questions about this Colombian necklace, and remember we talked about that?
Yes.
Do you know what a Colombian necktie is?
I've heard stories of Colombian neckties.
And what is a Colombian necktie?
My information is that it's a tire that would be put over someone's neck and set afire.
That's a Colombian necktie?
That's what I've heard. I've never experienced them.
Have you ever heard of a Colombian necktie being a situation where in a drug, I can ask this question, Your Honor, as an expert? Thank you. Have you ever heard of a Colombian necktie being a situation where in a drug killing, a person's throat is slashed and their tongue is pulled down through their neck area? You ever heard of that?
No.
All right. What you talked about was a necktie that used in South Africa, isn't it, where tires are put over someone?
I thought that's what you were referring to.
No, we're talking about Colombia, not South Africa.
Well, I don't know where these things occur. The
All right.
only necktie reference I've heard is with the tire.
All right, sir. Now, you were the detective on the Wonderland case, isn't that correct?
That's correct.
And was that a drug case? Involving
Yes.
drugs? Was that a drug case that involved knives?
No.
Was it a drug case involving killings?
It involved killing, yes.
Was there a knife involved in that case at all?
There were no knives involved in Laurel Canyon, no.
But in that case, there was a drug killing that resulted in which you investigated, is that correct?
There were several. There were 4 of them, yes.
And how long ago was that?
That was in July 1st, 1981. 81.
Well, now, this morning I asked you some questions about Faye Resnick, and you are aware, because you have seen records subpoenaed from a drug treatment facility called Exodus, isn't that right, regarding Faye Resnick? You've seen those records, haven't you?
I don't recall seeing any records like that.
You're the lead investigator in this case, and you've never seen any records from a drug treatment facility called Exodus?
Faye Resnick became a witness after this case was filed and dealt with the district attorney's office, and I wasn't present for those interviews.
I understand all that, but have you ever seen those records from Exodus?
Again, I don't recall ever seeing those records.
Have you had occasion, in the course of your investigation, to have a review of this book allegedly written by Faye Resnick?
I have read the book,
You have read the book?
yes.
And when did you read the book?
Shortly after it came out.
And in that book, or after reading the book, if it's to be believed, you became aware, did you not, that Faye Resnick had a history. Can I finish the question?
Finish the question.
Became aware. I finished the question.
All right, why don't you push the code quickly? Thank you, counsel. Proceed.
Detective Lange, in the course of forming your opinion, this was not a drug-related, these were not drug-related killings. Did you take into account, in forming that opinion, whether or not Faye Resnick had moved in with Ms. Nicole Brown Simpson on June 3rd, resided there until June 8th, at which time she went through an intervention with friends and family into a drug treatment facility called Exodus, where she was still in on June 12th, 1994.
Initially, I didn't have that information. Subsequently, I received information she did not, in fact, move in with her permanently.
I didn't ask if she moved in permanently, sir. Can you get back to my question, if I can? Let me see if I can get it back to you so you're clear. The question was, if she lived there from June 3rd through June 8th, whether permanently or not, but during that time frame, and on June 8th, she went into Exodus, the drug treatment facility, and on June 12th, she was still in that drug treatment facility, would that have affected your opinion regarding whether or not this was a drug, possibly a drug-related killing?
Did not have that information.
All right, you didn't have the information. We understand that. Now, if you had that information, would that be something that you would want to check out?
If I felt that there were drugs and this was a drug-related murder, certainly. But
All right.
that wasn't the evidence that I had, and that wasn't the path that I pursued. I had nothing to lead me in that direction.
I understand. You've since said you found out information since this happens, and you've told Ms. Clark, did you not, that investigations continue, sometimes even when the case is going on. Isn't that correct?
That's correct.
Up to the minute this jury gets this case, the investigation may very well continue. Isn't that correct?
May well beyond that.
All right. And as a good investigator, don't you continue, and don't you, as an investigator, try to develop evidence as it comes forward? Isn't that correct?
If it comes forward, I certainly do.
All right. You don't turn a blind eye on evidence just because it might point toward Mr. Simpson's innocence, do you?
Just the contrary.
All right. So you would follow any particular lead, and any such lead regarding possible drug involvement would be important to you as an investigator. Isn't that correct?
If I felt that this case involved drugs or drug dealers, it would. The fact is, it doesn't.
All right. Well, I'm asking you, you said there's new information that you have afterwards, so that you've already made a conclusion in this case that no matter what you heard about drug involvement or Faye Resnick, you don't plan to look into that. Is that what you're saying to us?
No. The fact that the victim may have a friend who uses drugs, and in light of no other evidence in that regard, has very little consequence to me. The fact that every bit of evidence that I have in this case points towards the defendant has a lot more to do with this.
Every bit of evidence you have, is that correct?
That's correct.
All right. Well, so that you have made your own judgment. In fact, in this case, you submitted this case to Ms. Clark for filing, did you?
Yes, I did.
So you submitted for a filing on June 17th to Ms. Clark, right?
That's correct.
And then she then filed this case, right?
That's correct.
And before you submitted this case, you had heard or seen Ms. Clark on television saying this was a sole murderer case. Isn't that correct? You'd heard that, hadn't you?
Objection, Your Honor.
It's hearsay. Just
Well, did you ever hear Ms. Clark say,
though it's a question. There's no answer.
did you ever hear Ms. Clark say, when you were present, this was a sole murderer case?
That's so. I'm going to sustain the court's own objection. That's irrelevant, what he heard Ms. Clark say.
Well, when he gives this theory, I have a follow-up
Well.
question. All right. At any rate, when you filed this particular case and you told us this theory was a sole murderer, was that your theory or Ms. Marcia Clark's theory?
My theory has always been there is one murderer.
Was that your theory or Ms. Marcia Clark's theory?
I don't know what her theory is. I believe her theory is the same as mine.
And you've discussed that with her, have you not, during your many conversations?
As to the one-person theory,
Yes.
it's been brought up.
All right, and when you discussed it and you went over your testimony last week before you testified yesterday, you talked about that, didn't you?
The fact that we believe there's one murderer?
No, talked about the one murder theory, yes.
Yes.
All right, and you were prepared when she asked you those questions yesterday, isn't that correct?
Yes.
Now, in that connection, you told us that you've read Faye Resnick's book, right?
That's correct.
And so that we're clear, you're saying to us that even if you knew that Faye Resnick had lived at the residence of 875 South Bundy and had used drugs at that residence between the period of June 3rd to June 8th to such an extent that she had to go into a drug rehabilitation facility, and that she had no job by which to pay for these drugs,
Objection, Your Honor.
and that,
Objection, Your Honor.
and that, may I conclude, Your Honor?
That's not evidence.
Overruled.
And that as of,
Hypothetical question.
thank you, and as of June 12th, she's still in that facility. You're telling us as an experienced investigator that wouldn't cause you to even or to consider that this might be a drug killing. Is that right?
I didn't base my investigation on what I read in the book. I based it on the facts and the evidence that I had.
That's what I'm asking you about, based upon the facts and the evidence. Is there any doubt in your mind as you sit there now that Faye Resnick was in Exodus, a drug treatment facility, on June 12th?
Objection, relevant, hearsay.
Overruled.
I don't know if she was or not.
As an investigator, have you checked that out?
Personally, no.
All right, so you haven't. So would that be something that, as an experienced investigator who wanted to get at all the facts, wouldn't you want to check that out?
Not when that was being handled by the district attorney's office after the case was filed.
Not when what, sir?
The interview of Ms. Resnick and her background is being handled by the L.A. District Attorney's Office subsequent to filing.
But didn't you tell us the other day that Van Adder interviewed her also, was present at that interview?
He was present during the initial interview, that's correct.
And you're both co-lead investigators, isn't that correct?
That's correct.
And don't the two of you ever talk about this case?
All the time.
And has he ever discussed with you what Faye Resnick said?
Not to any great degree.
You never talked about it?
We've talked about certain things,
And-
but again, not to any great degree.
It was of no interest to you so that it would cause you to want to go out and check out that possibility of a retaliation for failing to have paid for drugs obtained after June 3rd, 1994.
Sustained. It's a hall problem. That's a hall problem.
Thank you. Now, you mentioned also that you searched the Nicole Brown Simpson home for various things. When did you conduct this search for the drug paraphernalia and sort of things of that nature? When was that?
I've been through the house on several occasions, beginning on the 13th.
On the 13th, I thought you told us earlier that you just basically went through the house and you left by 12 o'clock. When was it that you searched for drugs during that period of time?
On the 13th, I looked for drugs, drug paraphernalia,
Right.
drug debris.
Had drugs come up by that time?
Have drugs come
Had
up?
drugs come up by the time you were searching on the 13th?
I saw none.
No. I'm asking you, you said that you were searching for drugs. What was making you search for drugs on June 13th?
That was part of my superficial investigation. I always check for things such as drugs, handguns, large amounts of money, things of this nature.
And part of your superficial investigation took how long? About 15 minutes?
No, I believe I was there for several hours.
Well, we know you were there for several hours, but how many times, how long were you searching?
Within the house?
Yes, inside the house, the interior of the house.
I was probably in and out of there several times, perhaps as long as an hour and a half, 2 hours. 2 hours and 45 minutes, it's hard to say.
And how much of that time was spent searching, Detective?
I'd say the whole time was spent looking at things, noting things.
And while you were doing this, you, by the way, didn't take any photographs of that interior other than the knife and the things down on the kitchen counter. Is that right?
The only photographs taken at that time were of the knife on the counter, yes.
Is your answer yes?
Yes,
That's the only-
yes.
All right. So you didn't take any photographs of anything that you searched and any drawers you looked in upstairs. Is that correct?
That's correct.
Did you ascertain and find out which room Faye Resnick might have lived in that house from June 3rd to June 8th when you were there on the 13th?
I didn't know who Ms. Resnick was at that time.
All right, so you didn't know where to look. Is that a fair statement?
I didn't know who she was or anyone else at the location. We hadn't even earlier had the victim identified until we found her identification in her room, and we made positive identification.
Your answer is you didn't look and you didn't know where to look as to which room Faye Resnick may have occupied. Is that right, sir?
I didn't know who Faye Resnick was.
All right. Well, when you found out who she was, did you go back and look?
No.
Have you ever personally talked to Faye Resnick yourself?
Yes.
And when was that?
About an hour and a half ago.
Today?
Correct.
Over the telephone?
She called, yes.
Is that over lunch hour?
Yes, it was.
Is that the first time you ever talked to her?
Other than in passing and greeting, yes.
You were not present when she was interviewed before, is that right?
That's correct.
Now, as I understood your testimony this morning, did you indicate that you cannot tell us which of the two individuals in this case were killed first, neither Mr. Goldman or Ms. Brown Simpson? Is that correct?
That's correct.
And with regard to Mr. Goldman and the fight that he put up prior to losing his life, Dr. Erwin Golden, Goldin, is the forensic pathologist who did the autopsies in this case. Is that correct?
I believe it's Ulden. Dr. Golden, yes.
Okay. Goldin?
Yes.
All right. He is the doctor, the expert. Is that correct?
He's the pathologist who performed the autopsies.
And you were present, and you've seen him testify at the preliminary hearing and other times in this case, have you not?
Yes.
And do you recall Dr. Golden describing the bruises and abrasions on Mr. Goldman's knuckles as follows? Counsel, this is from the preliminary hearing, page 96. Question, and in general, as in brief, how would you characterize those wounds? Answer, basically there are multiple abrasions involving the forearm, including the outer or lateral aspect of the forearm, where there are multiple abrasions. That means scratches. Some were not scratches. They were irregular in configuration. On the top of the hand, there were fresh bruises, abrasions, on the knuckles. And I went into detail on which fingers and which knuckles. Remember him so testifying?
No.
You don't remember that?
I don't have an independent
All right.
recollection.
All
I'm
right.
not saying it didn't happen.
Would it be helpful for you to read it yourself?
No?
All right. There are abrasions, bruises. I will look it up, Your Honor.
Overruled.
There are abrasions.
Hearsay at this point. Sustained.
Your Honor, this is with regard to exception. May I approach? This is not hearsay. With regard to this one, is this his expert?
Nope. Sidebar.